Okay. Okay, good afternoon, everyone. I want to welcome you to the 2024 Earle Zehmer National Workers' Compensation Moot Court Program. My name is Jacqueline Steele, and I'm one of the chairs for the Competition Committee, and we're so excited to present our program here today. I wanted to share a little bit of the information about our program because it is a multifaceted program that has been in the works with the students working very diligently for several months to lead to this day. And I think sometimes people who come and attend may not know how much they put into all of this, so I wanted to share that. We had, this year's competition had 23 student teams that appeared from 8 different states, including Florida, Arizona, Texas, Michigan, Mississippi, Virginia, Tennessee, and Louisiana. And they were judged in virtual preliminary and Sweet 16 rounds in July after turning in their written briefs by over 50 judges that have participated throughout the course of the competition leading today from 11 states representing Florida, Mississippi, Tennessee, Louisiana, Kansas, Kentucky, Georgia, Oklahoma, Missouri, Virginia, and Rhode Island. And we have a variety of awards throughout the competition, and we'll be giving those awards a little later in our programming while the court is deliberating. But we are so very fortunate to have the partnership between the Workers' Compensation Institute and the National Association for the Workers' Compensation Judiciary. Many may not know the whole background kind of history of this program, but it started approximately 38 years ago as a very regional program where there were, at the time, just a few of the Florida law schools in existence and participating in one law school out of Georgia. And we have expanded to a national program and are so very fortunate to have those sponsorship with the National Association of the Workers' Compensation Judiciary because they have the contacts in other states and have been so they've done such a good job in advocating for other law schools to gain interest and to participate in the program and to help us achieve the excellence in this presentation that we've been able to, and to draw this talent of the students. What I am sure you will walk away from this program today feeling is that we have amazing talent coming up through the ranks, and these law students are going to give you an excellent presentation today, and we're so very fortunate to have them. I will introduce, this is the first year in our national program where we have done a problem that is Tennessee, a different state from Florida, Tennessee law-based, and Judge Timothy Connor from Tennessee is going to come do a brief presentation to give you a little background information about the argument that you will hear once the court is called to order. So without any further ado, I'll give you Judge Connor.
Good afternoon. I was very honored to have been asked to write the very first non-Florida-based problem to be used in this particular competition. I have my own very long history with Moot Court. I loved Moot Court when I was in law school many years ago. And I've had the opportunity to coach various Moot Court teams over the years during the course of my practice. When I became a judge, I started teaching at a local law school where I have coached a Moot Court team there as well. So I was really honored, again, to have been asked to write this problem. So I'm just going to give you sort of a 2-minute description of the facts of this case, just so you'll have a sort of a basis for what you're going to be hearing from our excellent students today. This case involves a truck driver who has worked for a company called Overtime Transportation for quite a number of years. In that industry, some trucking companies participate in an event called the Trucking Rodeo. And the Trucking Rodeo is basically it's a friendly competition among various trucking companies where they send a team of drivers and the drivers participate in these various events using their tractor trailer rigs. They go through obstacle courses. They have competitions like how to backing your trailer up as close as you can get to a dock without hitting the docks, events like that. So this particular case involves a gentleman who was asked / pressured into participating in this trucking rodeo. And while he was participating in this event, in his tractor trailer rig, he was not wearing a seatbelt, which arguably violated a company rule. And he was injured when he was backing his truck up and it struck an obstacle. He sustained, I believe, a neck injury as a result of that. So there are a lot of questions in this case, two of which are substantive and one of which is procedural. The substantive issues have to deal with affirmative defenses in workers' comp cases, one of which would be the willful misconduct defense. So in Tennessee, our courts have adopted Professor Larson's 4-part test for willful misconduct. So that's one of the issues in the case. Also in Tennessee, there is a statute addressing an employee's voluntary participation in a recreational activity. And there are conditions under which if an employer can prove certain elements of that statute, that also becomes a defense to the workers' compensation claim. The other issue in the case is more procedural. It involves an effort by one of the parties to obtain discovery from the other party's expert. And under Rule 26 of the Tennessee Rules of Civil Procedure, which is modeled after the federal rules of civil procedure, there is language in that rule that seems to limit the opportunities for one party to discover expert information from another party's expert through the use of either interrogatories or depositions. In this particular case, one party served a subpoena ducis tecum on the other party's expert, essentially asking for a copy of that expert's entire file. So the procedural question is, can one party use a subpoena ducis tecum in an effort to obtain discovery from the other party's expert? So those are the issues in the case. I know that these students are going to do an excellent job before the first District Court of Appeals, and I think that you will really enjoy the program. Thank you.
All rise. First District Court of Appeal, aka the Tennessee Supreme Court, is now in session. All that business before this court, draw near, give attention, you shall be heard. May God save each and every.
Thank you. You may be seated. We have one case on our docket this afternoon, the case of Richard Dilbert versus Overtime Transportation, LLC. Appellant's counsel, when you're ready.
Chief, I think they're going to turn the lights down.
Yeah, it would be nice to bring the lights down because we can't see.
That's getting better.
That's nice.
There we go. Here we go. Counsel?
Good afternoon, Your Honors. My name is Reem Alpador, and I represent the appellant, Mr. Richard Dilbert. Today, I will be discussing the motion to quash, and my co-counsel, Nicholas Langenberg, will discuss the summary judgment issue. Before we proceed, may we please request 1 minute for rebuttal?
Noted.
Thank you. It is imperative that a party gain access to documents in which a testifying witness relies, whether an expert witness or not. Because the lower courts did not hold in this way, this court should reverse regarding the motion to quash for 2 reasons. First, Tennessee Rules of Civil Procedure 45.02 and 26.02 subsection 4 permit the use of a subpoena ducis tecum on a vocational expert. And second, Overtime did not adequately object to the documents being privileged under the work product doctrine.
Couldn't this procedure have been accomplished through just simply a deposition ducis tecum?
Your Honor, Mr. Dilbert could have gained a deposition, gaining his documents through a deposition, but 45.02 allows a party to request a subpoena to gain access to documents from another person. And under that rule, Mr. Dilbert's subpoena was a permissible method of discovery. In State versus DeBerry, this court emphasized that discovery procedures must be interpreted broadly, and it also specified that the whole code canon controls, so that the rules of civil procedure as well as other statutes must be read in conjunction with one another. So although Rule 26.02 subsection 4 states that interrogatories and depositions may be used by a party to request documents from an expert, 45.02 allows a party to use a subpoena ducis tecum. Additionally, in Starnes versus Akinlaja, the Tennessee Court of Appeals stated that Rule 26.02 subsection 4 does not provide a ceiling for what can be discovered about an expert witness.
In Rule 26, what do we do about the only in that provision that materials may only be obtained through interrogatories and depositions?
The only language is there in 26.02 subsection 4, but it also states that discovery of facts known and opinions held by an expert may only be obtained through interrogatories or depositions. And Overtime below did not assert that these documents were facts known and opinions held by the vocational expert. Additionally, Overtime below made an argument that the documents that Mr. Dilbert requested were protected under the work product doctrine. However, Overtime did not adequately assert that these documents were privileged. Under Rule 26.02 subsection 5, a party that objects to discovery based on the fact that the documents are privileged must at least state the nature of the documents that it asserts to be privileged, and Overtime did not do so in this case.
Can I ask you, why do we have jurisdiction of this order? Is this not an interlocutory order?
This court does have jurisdiction over this order because the Court of Appeals, or the Tennessee Workers of Compensation Appeals Board, specifically ruled on the summary judgment issue, as well as they stated that the motion to quash could be disregarded because they granted Overtime summary judgment. So this court does have jurisdiction to hear the Tennessee Workers of Compensation Appeals Board's decision.
And assuming we do have jurisdiction, the subpoena was served on October 5th with production due on October 20th. That's less than 21 days under Rule 4507. So wouldn't that alone be a basis to quash the subpoena?
Respectfully, no, Your Honor. Mr. Dilbert's subpoena did not have the required time under 45.07, the 21 days, but Overtime could have consulted with Mr. Dilbert's counsel to extend that time. And additionally, in Oldham versus Freeman Webco Realty, a case that is extremely similar to the facts of this one, where a party didn't have 21 days in their subpoena to respond, the Court of Appeals stated that party could have simply asked an extension from the court instead of seeking a motion to quash. So similarly, in this case, the trial court could have extended the time requirement under that subpoena instead of just quashing the subpoena. And moreover, the trial court's opinion in quashing the subpoena was not based on the time requirement. It was based on the fact that the products or the materials that Mr. Dilbert requested were protected under the work product doctrine. But that was an error because Overtime did not comply with the procedural requirements to assert the work product doctrine. Overtime did not provide a privilege log. Overtime did not assert that any of the state the nature of any of the documents it asserted to be privileged. And for that reason, the trial court judge erred in granting Overtime's motion to quash. In Starnes versus Akinlaja, the Tennessee Court of Appeals heard a case that was also similar, in which the party that was requesting discovery requested all correspondence between the company and its vocational expert. And the Tennessee Court of Appeals stated that not all of those documents were likely protected by the work product doctrine. And the party that was objecting to discovery must have provided a privilege log to the trial court set to outline why the documents that they asserted to be privileged were privileged. And the court ordered that the trial court conduct an in-camera inspection to demonstrate so that the party objecting to discovery could demonstrate why those documents were.
As this is a case of first impression before us, the Supreme Court, and we're the keeper of the rules and the maker of the promulgator of the rules, why is the rule that you are arguing for the best rule for Tennessee going forward?
This is a case of first impression. That is correct. This rule is important for this court to adopt because this court has repeatedly emphasized, for example, in Greenville Ready Mix versus Incorporated, this court has emphasized that open discovery is favored between parties so that the court and the parties in litigation can analyze all the facts before them. In this case, Mr. Dilbert was denied access to discovery and denied access to materials that he needed to adequately prepare for trial. Without these documents, Mr. Dilbert would not be able to prepare for trial and be ready for trial in the way that he deserved to be. And for that reason, we ask this court to reverse and remand. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Nicholas Lingenberg, and I also represent the claimant appellant, Mr. Richard Dilbert. Because workers' compensation offers the exclusive remedy for a workplace injury in Tennessee, it is important that an injured worker's claim not be dismissed summarily unless the employer has shown that there are no factual disputes that must be resolved at trial. The Court of Workers' Compensation Claims correctly recognized that this case is not ready for summary judgment because there are genuine issues of material fact regarding both the affirmative defenses raised by the employer. Therefore, the decision of the appeals board should be reversed for the following two reasons. First, because the employer has provided insufficient evidence to show that there are no issues of fact regarding any of the four elements of willful misconduct. And second, because Mr. Dilbert's participation in the rodeo was both impliedly required and work-related. When considering whether a motion for summary judgment should be granted, it is necessary to consider the substantive evidentiary standard that applies in the case. Here, the employer bears the burden of proof regarding all of the elements of both the affirmative defenses that is raised. With respect to the first defense, that means that the employer must not only show that there are no issues of fact, but also that there is evidence in the record sufficient to satisfy all of the elements of willful misconduct, which includes showing not only that the employee knew of the rule, but that the employee understood that the rule existed to protect against the dangers posed by the conditions in which the injury occurred.
Let's go to the definition of willful conduct.
Yes, Your Honor. The definition of willful misconduct in Tennessee is defined by case law applying Dr. Larson's four-part test, and it requires an element of willfulness, which continues to be contained in the fourth element of lack of excuse.
What degree of willfulness? For example, most unemployment boards across the nation define willful misconduct as egregious behavior. So in this context, are you pushing for more of that, more of an onerous burden, or what's your support for that?
That question was addressed most directly in Colt versus Neville of Cleveland, where the court indicated that when considering a willful misconduct issue, we must distinguish between those cases in which an employee was merely careless or negligent and those in which a deliberate decision was made. It used to be that the court was more likely to use language saying that willful misconduct only applies in the most egregious circumstances, but in Mitchell, this court seemed to tone down that language, but still affirm that we must distinguish between negligence and carelessness and actual willful decisions to intentionally violate the law.
Well, and I assume you disagree with our decision, so why do you disagree? Why do we get it wrong in Mitchell?
No, Your Honor, I do not disagree. Here, Mr. Dilbert did not make a willful decision to not wear his seatbelt. If we, looking at page 9 of the record, when he reflects on the reasons why he did not wear his seatbelt, he indicates that it simply didn't occur to him. He was on an off-road course. He distinguishes this situation from his normal working conditions in which he would be on a highway or delivering loads or driving more than 25 miles an hour, and he specifically says that he didn't see anything else.
Well, doesn't that sound a bit willful? I mean, you get into the truck, and the normal thing to do is to grab the seatbelt and latch it. Here, are you saying that he thought, well, I'm not going to be on the road, I'm going to be off-road on a course? That sounds like a willful decision.
His specific language was that it simply didn't occur to him, but more than that, these drivers are getting in and out of the car on a regular basis as they're participating in this competition, and other drivers didn't seem to be wearing their seatbelts. And that actually goes to one of the other elements of willful misconduct. To prevail on this defense, which again in Mitchell, this panel indicated that bar is very high and appropriately so. If the employer is going to prevail on that defense, it must show that it continuously enforced that rule in a bona fide way. And yet there is no evidence in the record to suggest that the employer ever took steps to make sure that this rule was being followed at the rodeo. And the fact that Mr. Dilbert says that he cannot recall the rule being discussed at any safety meetings in 20 years, even though he can remember rules about loading dock procedures and strapping down loads. And
So the employer onboarding documents says you shall wear your seatbelt at all time. Mr. Gilbert signs that. And so what you're arguing now is that really that's a context-specific inquiry. If it's just regular driving, that's one rule. If he's off-road, that's another rule. If he's moving the truck in the company parking lot, maybe there's a third rule.
yes, Your Honor, for willfulness county defense to apply, it is the employer's burden to show that the employee knew the rule applied under the circumstances in which the injury occurred. And since the employer has provided no evidence here on that element, that alone would make this not appropriate to be resolved at the summary judgment stage. Moreover, because there is conflicting evidence regarding whether Mr. Dilbert could recall whether the rule was discussed ever in the past 20 years, and whether or not overtime was making sure that his drivers were wearing seatbelts at the rodeo, that all creates issues of fact that must be resolved by the trier of fact. And the same thing is true of the employer's other affirmative defense. When it comes to voluntary participation in a recreational activity, that defense will only prevail if neither of two statutorily created exceptions apply. If the event was sufficiently impliedly required or work-related, then that defense fails. And as was explained in Pope versus Nemco Cleveland, it is the employer's burden to show the exceptions do not apply. And in the record, and I should acknowledge that it is true that there are similarities between this case and Pope. In Pope, an owner wanted to put together a charity team for a mud run event, and the car dealership received the benefit of being known in the community as supporting this charitable event. And the court did conclude that in that case, neither of these two exceptions, that the factors did not rise to the level necessary for these two exceptions to apply. But the court also noted that it was a close call and that the inquiry is very fact intensive. Here, there are a number of factors that were not present in Pope. The employer provided pay for the employees on the first day of the competition. There were rewarded employees who won events with paid days off. They provided 2 tractor-trailer rigs for use at the event, and they received the direct benefit of advertising their company to other drivers. And if all of those factors were present in Pope, it is definitely worth asking whether that analysis would have come out differently. And the same thing is true with implied requirements.
Since we didn't, the intermediate appellate court didn't rule on that, if we agree with you, what do we do? Do we kick it back to them? Do we kick it back to the trial level? What's the remedy that you're seeking there?
Judge Mowbray, because the appellate board decided that summary judgment was appropriate here and summary judgment was not appropriate, the case should be remanded back to the trial court so that it can go forward to trial and the trier of fact can decide for itself what actually happened after weighing the evidence. Thank you.
May I proceed?
Yes, you may.
Good afternoon, Your Honors. My name is Olivia Tucker, and I, along with my co-counsel, Amanda Egra, represent appellees, Overtime Transportation, and Acme Insurance. I'll be addressing the first issue regarding the motion to quash, and my co-counsel will be addressing the second issue regarding the motion for summary judgment. This court should affirm the lower court's decision as to the first issue and hold that the motion to quash was correctly granted. First, because a subpoena duces tecum here is statutorily impermissible. And secondly, because a subpoena request work product and compliance would be unduly burdensome on a non-party expert. The Tennessee Workers' Compensation Bureau is bound by the discovery procedures that were established by this court. From the outset, a subpoena duces tecum served upon our vocational expert is impermissible because Rule 26.02, subsection 4, specifically provides that facts known and opinions held by an expert can only be derived from interrogatories and through depositions.
Why does that apply instead of 4502 allowing a broad range of discovery?
My friend on the other side did bring up Tennessee Rule of Civil Procedure 45.02, which does broadly authorize the use of a subpoena duces tecum generally. However, 26.02 subsection 4 is the carve-out here. If we were to interpret those rules together in the way that Mr. Dilbert's counsel seems to suggest, 45.02 subsection 4 would almost be null and void. if a subpoena duces tecum could just be used regardless, it wouldn't really make sense for subsection 4 to even have been passed. And Judge Austerhaus, you asked specifically about the only language in subsection 4. Similar language was at issue in front of the United States Supreme Court in Milner versus Department of the Navy. And there the court held that the provision should not be broadly construed because it was explicitly made exclusive. And here the only language in subsection 4 is similarly explicitly made exclusive, especially considering the provision 45.02, which also provides that a non-party expert should be afforded certain protections from undue burden in complying with an unreasonable discovery request. And the discovery request would be unreasonable, which is why, Judge Thomas, as you mentioned, a deposition would have been more appropriate to narrow down the claims, to then issue a new subpoena so that the claims would not be so broad and sweep over such a broad.
The appellant seems to argue that you sat back, that you didn't object, you didn't provide notice of your objections to the subpoena. Did you not have a duty to file some form of motion for protective order, anything declaring the reasons for your noncompliance?
Below, we did raise the work product doctrine. We did raise that objection. My friend on the other side seems to think that a privilege log should have been more appropriate. However, under this court's precedent in Hawkins versus Superior Motors, this court explicitly stated that a privilege log is not required for work product. And below, we did raise the objection, the nature of the documents, that they aren't discoverable because they do contain.
So if that's your argument, how's the other side to determine or know that you're declaring work product? When you do a privilege log, you indicate you're objecting, you're not disclosing due to work product. If you don't have a privilege log filed, how is your opponent supposed to know what positions you're setting forth or why you're refusing to comply?
Judge Dilbert did bring up the 21-day discrepancy here. The subpoena was served on October 5th, and we were given 15 days to comply, which is 6 days short of the minimum in 45.07. So had we been given the appropriate time set by this court to serve that objection, we could have done a privilege log. We could have done something more in detail. But because we were deprived of that time, that it was made so explicitly clear by this court, the standard of review here is for an abuse of discretion. So because the subpoena on its face was facially deficient, because of that time discrepancy, the lower court did not abuse its discretion in granting the motion to quash. And because the subpoena does include work product, 26.02 subsection 3 comes into play here, which holds that the work product can be discoverable if the party has a substantial need for the materials and is unable without undue hardship to obtain the substantial equivalent. And here it would not be unduly burdensome for Mr. Dilbert to obtain these materials through alternative means. Looking on page 18 of the record at the first request in the subpoena for all correspondence between Overtime and our expert, correspondence is a two-way street. That can be acquired straight from Overtime, which is a party to this litigation. And as it pertains to the third request for the data relied upon by the expert assessing Mr. Dilbert's work history, his work history can similarly be sought from Overtime itself, which is again a party to this litigation.
As this is a case of first impression, and so we have some latitude here with the rules and in our rulemaking capacity as a Supreme Court, perhaps that's for another day. But why is the position you're arguing for the best rule? Where we have to think about the case that comes next. Why is the one that you're arguing for the best rule? And though it's not maybe in conformity with our previous policy that we like broad, discoverably broad.
Your Honor, it is true that Tennessee courts have recognized that discovery procedures should be broad. However, broad does not mean limitless. And this court was explicit in drawing those limits, specifically in subsection 4, with only interrogatories and depositions. And it is not as if Mr. Dilbert is barred from forever obtaining this information. He can do it through interrogatories, he can do it through a deposition. It's just the rule that he argued below was incorrect. And therefore, to compel compliance with the statutory provisions set forth by this court, the decision of the lower court should be affirmed. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. My name is Amanda Egra, and I also represent overtime. Summary judgment was appropriate in this case because there are no material facts in the record upon which reasonable minds might differ. As such, the appellate court should be affirmed for two independent reasons. First, the employee was engaged in willful misconduct. And second, his participation in the rodeo was voluntary. There are four elements to a willful misconduct defense that my friend on the other side recognized, and the first of which is notice of the rule. On page 16 of the record, Overtime has submitted a copy of the handbook where Mr. Dilbert signed, acknowledging that he received training on this rule and that he understood the rule. And this court held in Mitchell versus Fayetteville Public Utilities that this constitutes actual notice.
Do you think that when he signed that he was thinking about he's being hired to do the job of a truck driver, so on the road hauling goods from A to B, and not necessarily if he's moving the truck in the parking lot or involved in a contest where they're in and out of the truck or trucks or what have you?
Yes, Judge Osterhaus, you asked opposing counsel if this was a context-specific rule, and it is not. The handbook explicitly states that seatbelts are to be used when operating a company vehicle. And Mr. Dilbert was operating a company vehicle when he was injured. Opposing counsel suggests that there's no evidence in the record to suggest that this would cover this specific instance. But again, the handbook could not be more clear. Seatbelts are to be used when operating a company vehicle, and that's what Mr. Dilbert was doing, and he had notice of this.
Does the record reflect that the employer ever enforce this rule with respect to the contest?
Your Honor, the record does not reflect that specific provision. However, that is another element of the defense, bona fide enforcement of the rule. And Overtime submitted an affidavit saying that it enforces the rule and goes on to say different levels of enforcement, verbal warnings, written warnings, up to termination, and has testified that it has terminated employees in the past for violating safety rules.
And why not more appropriately a jury question?
Your Honor, the evidence in the record is sufficient for summary judgment because not only did Overtime testify to enforcing this rule, but Mr. Dilbert has not rebutted it. Mr. Dilbert has not suggested that others have not been disciplined. And as to your question about was this a willful decision, Mr. Dilbert's deposition states that he looked around and saw that others were not wearing their seatbelts, which suggests an affirmative decision on his part to not wear his seatbelt.
Well, following up on Judge Thomas's question, though, did the appellate court use the appropriate standard in evaluating the summary judgment? On page 4 of their opinion, they say, we conclude the preponderance of the evidence supports a finding that employee engaged in willful misconduct. Is the appellate court or any court on summary judgment entitled to determine just by the preponderance of the evidence that summary judgment is appropriate?
Yes, Your Honor, the court is entitled to make that determination based on the facts in the record. And here, the facts in the record warrant a grant of summary judgment because there are no material facts in dispute.
Well, I would agree with you that if no material facts in dispute was the finding, then that would be the appropriate summary judgment standard. But preponderance is what a fact finder typically would be involved in. So perhaps it was just the misuse of the language by the appellate court, but shouldn't we at least kick it back to them to say, did you really mean that you assessed just the preponderance of the evidence instead of determining that no material facts support summary judgment?
Your Honor, the appellate court should still be affirmed in this position regardless of the preponderance language because we can see here as a matter of law that the finding is correct, that there are no material facts in dispute. And the judgment of the court was correct in this instance. The employee was engaged in willful misconduct and furthermore had no excuse for not putting a seatbelt on. This court has held that convenience is not an excuse as well. And when an employee is of seasoned experience, the risks of his employment are known to him. Mr. Dilbert is a truck driver of over 20 years and surely knew the dangers of not wearing a seatbelt. It's another element of the defense.
How about the other part of the argument? Did Mr. Dilbert, your colleagues say Mr. Dilbert participated here as part of his job? He was paid for participating and he received potentially bonuses, rewards for participating. Why isn't this an on-the-job accident?
Your Honor, opposing counsel is correct in raising Pope versus Nebco. That is a really great case, and the facts are similar to the instance here. And that case says that we must look at the relationship between the employees. And here, Mr. Dilbert was not pressured by his supervisor to participate. He was not impliedly required for that reason.
But he was pressured by a supervisor, though. Would you at least agree with that?
That is correct, Your Honor. He was encouraged by another supervisor at the company. However, it wasn't his direct supervisor. And his supervisor.
But if we look, let's look at it as not encouraged, but how about rewarded? Your client actually gave 2 additional paid days off to anyone who participated in this function. You got a day off from work on Friday. There was advertising on the truck door. They allowed use of the truck to participate in the competition. So are we just looking at encouraged to do so, or isn't there also a benefit element?
Judge Thomas, Pope versus Nebco held that rewards are not dispositive. So in this case, the rewards to the employees were minimal. What's more important here is that Mr. Dilbert was not pressured to participate in the event. His supervisors did not ask him to participate, and they were not even in attendance on that day. And just one supervisor at the company also is not enough to raise this to the impliedly required standard. If the supervisor was a janitorial supervisor, that wouldn't be enough to make this a required event. Summary judgment is an important piece of our judicial system, and it must be granted when there are no material facts in dispute. As such, the appellate court should be affirmed. Thank you.
Thank you.
Your Honors, Overtime's counsel has argued that its evidence shows a lack of factual disputes. But because Overtime is the party that would bear the burden of persuasion at trial, it must show not only a lack of factual disputes, but that also its evidence is so powerful that no reasonable jury would be free to disbelieve it. Overtime has not done that in this case, and so it must be allowed to go to trial. And when it does go to trial, it is imperative that Mr. Dilbert gains access to the data on which Ms. Goshawk, the vocational expert, relied on. Judge Thomas, you asked my opposing counsel how Mr. Dilbert could have evaluated Overtime's work product objection without being provided a privilege log. He could not have. In the record, in pages 3 and 4, that demonstrates that Mr. Dilbert was not given an opportunity to see whether Overtime's objection was proper. Overtime should have provided a privilege log. It should have complied with 26.2 subsection 5. It did not do so. We ask this court to reverse the remand.
Thank you, counsel. And thank all of you for your excellent arguments. We're adjourned.
Rise.
Okay. While the judges are deliberating, I'm going to go through some of the awards that were offered or given based upon different aspects of the competition that I described that occurred earlier. And the first award that we provide for the students to earn an opportunity to receive is the Best Written Brief Award. And again, all of 23 of the teams submitted written briefs about 4 to 6 weeks before they did the preliminary oral arguments. And we are in a unique position this year to have had a 3-way tie, and this statistical likelihood of that, it's sort of amazing when you think about it, because we have 3 different judges that grade all 23 of the briefs and submit a written score, and we had 3 teams that had the identical best score. So those teams were Team 7, that was from Jacksonville University College of Law here in Florida. Team 24 from the, I'm sorry? Team 20 from, Team 20 from University of Houston Law Center in Texas, and also Team 4, and I believe representatives from Team 4 are here with us today and I'd like them to come forward to receive that award, from Mississippi College School of Law. So is there a representative here from Mississippi College, the students? I'm sorry, it's 24. I had it. I apologize. Go ahead, team 24. If you're from Mississippi College for the written brief. Okay. Mississippi College, Team 4. I apologize. If you'd come forward. I had 24.
It was 24. You were right. I
Oh,
apologize.
okay.
Four is
It was
also vested.
24.
No, it's not.
Okay.
It was 4, 7, and 24. 4 is here.
Oh, 4 is here.
Yes.
So, okay, so
4 is from
24
Mississippi.
received the award
They
and
did.
they are not present. Okay, I apologize for this confusion.
But 4
Okay.
is here. Please come up.
Okay, so come up to receive your award, Team 4, because Team 4 and 7 and 24, all 3 received the best brief. Team 4, I misunderstood what team was present to come forward and receive the award. So my apologies, and if you would come forward now. Congratulations. Okay, second place for the Written Brief Award. They are not present with us here today, but that was Team 14 from Nova Southeastern Shepherd Broad College of Law here in Florida. Then we also had an award given for the Best Individual Oral Advocate. And just to give a little bit of a background to the audience, that student is the single best student receiving the highest combined score from 2 different preliminary rounds out of the 46 students that argued in the entirety of the preliminary round portion of the competition. And that Best Individual Oral Advocate was Anderson Tittle from Team 20 with Baylor University School of Law from Texas. I believe that student is present, and if they would come forward. Amazing job. Congratulations to you. Yes. I do want to take just a few moments while the judges are continuing to deliberate to thank again the National Association of the Workers' Compensation Judiciary and the president, as well as all of the judges that volunteered. We are one of the few competitions in the country that afford students the opportunity to argue in front of actual sitting judges at every phase of the competition. And that's an invaluable experience for the students to gain constructive criticism and tips, and to be able to appear before so many sitting judges during their law school career. And we would not be able to afford that opportunity without the partnership with the National Association of the Workers' Compensation Judiciary. We also, again, want to thank Judge Connor from the National Association of the Workers' Compensation Judiciary for putting together really just an excellent problem, and the packaging of the materials for the record and the information that the students utilize to write their problem, to write their brief, and to prepare for today's competitions. So I will check on the status of the deliberation, and once the court's called back to order, the judges will announce who won the competition. And thank you all for being here.
You may be seated.
Again, really wonderful job by both sides, by all counsel. I can really tell the work that you put into it. I know that weeks and months of hard prep goes into these moot court competitions, and you really did a fabulous job, in line with what we see on a regular basis from counsel that are out there, appellate counsel. So really good. Let me turn to my colleagues. Judge Thomas, do you want to go first with any particulars?
Sure, well, and we're always so impressed with the performance levels, and we said back there that we'd love to have each of y'all come argue with us regularly. You did such a fabulous job, and a lot better than we see from seasoned attorneys, so you should be really proud of yourself, and I'm really impressed, and I know you'll all have wonderful futures ahead. Just some couple of notes that I made, just some positive feedback. Everybody, beautiful job with eye contact and having conversational tone, because when we speak to people about what is the purpose of an oral argument, one of the key things that I was taught as an appellate attorney, and then now I appreciate on the bench, is it's supposed to be a conversation. So it's like you and I are having a conversation with us about a case. And the most effective, persuasive oral arguments are ones that are just like a conversation. I'm asking you questions and you're talking to me, and I encourage you to always feel like, it is a conversation. We regard it as that. There's no problem with you asking me a question. For example, if I asked you a question and you gave me the response, but you're not quite sure if you understood my question, or if you hit the area that I was looking for, there's nothing wrong with you saying, Judge Thomas, did I answer your question? And that's appreciated. Sometimes I say, not really, because I'm interested in this aspect. And then I can clarify for you what I'm thinking. I'm about to go decide the case, and I'm advertising to you what's going to turn my opinion. So always feel like it's a conversation, and I thought each of you did a fantastic job about referring to us by name. That shows you're comfortable and confident. And I also was extremely impressed by all of you referring back to a question one of the panel members had of your opposing team. Because if it was something that you wanted to clarify, obviously you think it's important, or you wouldn't have asked the question. It's great strategy when you come back up for rebuttal, or when you're, the appellee, when you're, before the podium to talk about questions that were asked by appellate. And then on rebuttal, hit things that we've asked before. So I was very impressed with you doing that. One of the things that I teach my law clerks that, by the time they leave, they roll their eyes when I say, what golden rule do I always teach you, especially as you go forth into practice, whether you're given a project as a young associate just to look at a file, or if you're preparing to go to an appellate argument, and that is, and they'll scream it back to me, number one, you sit down at a case and you think jurisdiction. I'm only looking at this case right now for jurisdiction. What questions can I be asked about jurisdiction? Do I have jurisdiction? And I'm going to anticipate every question, because you're going to get those, especially at the appellate level. Second, procedure. You wipe your brain out and you look at the case strictly on procedural grounds, answer every question on procedure, analyze every aspect that could be asked of you. Then third and lastly, merits. So, you all, I think, did a good job anticipating, but I think there was a question about standard of review, potentially from Judge Bilbrey, or also a jurisdictional question from Judge Bilbrey. So as an appellate court, that's our radar. So before you even start with the merits of the case, I should win because it's the right thing on my facts. You can't get there if there's a jurisdictional or procedural snag. So always emphasize that. I think you did, y'all had a great grasp of the cases, obviously, and I thought that was fantastic. Used our names. One of the things that, I think I would have done as the appellate's team was more emphasized, the essence of our judicial system is being able to go to trial, getting before that jury. I think I might have even, sort of embraced that, the the great essence of judicial system, don't deny my client his right to go before that jury. I think I might have pulled at our heartstrings with that a little bit, reminded us the basis of our judicial system, and that obviously summary judgment should be sparingly used. And I think, Olivia, you made a great comment. You said discovery is broad, but it's not, it doesn't mean limitless. Beautiful response to one of the questions. So anyway, I thought all of you did a great job. Thank you for participating. It's such a wonderful resume builder for you, an experience builder, and you should be very proud.
Thank you, Judge Thomas. Judge Weber?
Thank you. And, first of all, let me echo Judge Thomas's comments. Most of you may not know, or at least the non-attorneys out there, she's an almost 30-year comp practitioner. Before she came on the court, she's probably one of the few judges in the country, appellate judges, that has that kind of comp background. We haven't had a judge on our court having that kind of comp background for probably 40 years when they changed the structure of some of the courts in Florida. So when she's talking comp to you, she knows what she's talking about. So, and we're very fortunate to have her both for these cases and for our real life cases tomorrow that we have two tomorrow. The conversational tone is good. That means it's a good oral argument when you're having a conversation back and forth. And I think we had that with both sides today. And it was very close on trying to sort out, who was the team that prevails. As far as the individual comments, I'll just go through one at a time. I thought you had a good response to questions, good interaction. On the rebuttal, I was a little worried that you were going to try to do too much in the 1 minute, but you brought it in on your time, and I thought that was good. For the second, the good outline, the 2 points right at the start is always very helpful. Good response to questions, good record citation. The response to my remedy question I thought was good. The time got a little confusing. We weren't going to ding you on that because we've got 2 clocks going, but typically at mid-court you want to end right on time and or ask the court to have time to conclude if you're about to go over. But we didn't with multiple clocks, we're not going to hold that against you. On the appellees, good citation to the cases again, and good response to questions, and that's what I had written down for both of you. I didn't note who may have missed it just for some constructive criticism, but typically, at least in Florida, both sides get up there and the first thing they say is, "May it please the court." That's stupid and formulaic and archaic, but it's just kind of how things start out. So I would be sure, at least if you're doing a Florida mid-court, to start your argument with "May it please the court," even though it's kind of silly. But lots of practitioners get up there and they just kind of jump into it, and you're kind of waiting for the "May it please the court" and for the chief judge to give a nod or a proceed or something like that. So, but I thought both sides did great. I couldn't have done anywhere on that level back when I was in school. I probably couldn't be on that level now. So very, very impressed with both sides, and we did have a hard time sorting out who was going to prevail. So we appreciate all your good work.
Yes, thank you, Judge Billy. And I agree with both of my colleagues. Particularly what Judge Thomas has said about an oral argument being conversational. I think that's very important. We want to hear your best arguments, but we also want to poke on the stuff that's the underside of your argument, and for you to be ready to address those things and to clearly and confidently answer our questions, directly answer them, and then maybe put it back to your main arguments. We understand, and that's what you should do, and I think that you all did a very good job with that. We're poised, confident. I think that it was fun to ask a policy question. Where our normal job here is mid-level appeals court, so we don't get to act as a Supreme Court. So when you're sitting as a Supreme Court, you start thinking, wow, what can I do here? Particularly a rule-based case. in Florida, the Florida Supreme Court, promulgates the rules too. So as a Supreme Court, you start thinking, well, what is the best rule for this situation? What are the difficulties with having only in Rule 26, but then Rule 35 being this broad thing, and how do those fit together? And what can we do to improve that as the head of the branch, so to speak? So it was fun for me to ask the policy questions, and I think that both of you did a very good job answering those. I appreciate that. Yeah, you were clear, you were concise, you ended the debate on time. I couldn't figure out the clock, so it seemed like it ended when it should have, so good job with that. And both sides, you really did a good job. We went back and forth back there as to the strengths of both sides' argument, and it was very, very difficult decision as to picking a winner. But that is our task here today ultimately, and we decided that appellants in this case have won the competition. So, well done. I'm not sure what we do from here.
Where are the teams from? Can we know where the teams are from? No. Michigan State, wow, thank you for coming down, that's great, yes.
We are also from Michigan State.
Oh, really? Holy cow, that's great.
A day for Spartans, wonderful. Wonderful.
Well, it was close. Y'all can pull on the award.
Very good. Well, we're adjourned. I think we're going to take some pictures, but otherwise we're adjourned. Thank you for coming.
Thank you.
Okay. We'll get a chance to say.
Congratulations.